Yep, I'll stay seated. Y'all want to tell me what we're working on today?
Your Honor, with the court's permission, I'd like to introduce myself. Ricardo Cedillo. I've been on the pleadings, but I've been in jury trials in 2 different states since the proceedings began. So I'm here today, and I want to introduce myself. I want to tell you guys that I came bearing gifts. If I may.
Lavish gifts.
Lavish gifts, Your Honor. If I may approach.
Amen.
Your Honor, this morning we e-filed an anti-SLAPP motion under Chapter 27, I think. And we have a courtesy copy to the court that I'd like to leave with you. Obviously, it's not on the docket for today. And then these other notebooks, Your Honor, we've assembled the case law and the citations there for you, and we put them down in federal order. And it ended up taking 2 big notebooks. And we've provided the closing counsel, of course, to do come to accept what we're providing for the year. And I don't know how many anti-SLAPP motions, statutes only a year or 2 old.
It'll be a first, so.
It'll be a first, and you know.
And you've got that much case law?
Yes, it does, actually. But it's a good thing to kind of peruse through as you're watching Cowboys beat the Eagles this weekend, or you know, for your reading pleasure. It's actually pretty fast reading. I think that if you devote maybe an hour or so for the body of motion, the case is finished. It is something I think that
we're going to try to set that at that same date in December or something like that.
Well, Your Honor, the one aspect about the motion is that although it's got some leeway in it, you're supposed to act on it within 60 days. So the legislature built a short time on it. But of course, if your docket doesn't allow it, there's provisions for that. And then I think there's a 30-day turnaround after you hold the hearing. So that's just one of the aspects of it. But when I introduce myself, I like to leave an impression. Here it is.
Very well.
Or can I put this down for you?
Oh, this is
right there. Good. Your Honor, one other point on that, and I conferred with Mr. Cappuccio. We left a message with Mr. Ray this morning after we filed it. Under the terms of the statute, all discovery is supposed to come to a screeching halt. The case is supposed to come to a screeching halt once the anti-SLAPP motion gets filed. We are not taking that position. And I don't know if we have to formally get an order to you to allow it, but what I've told Mr. Cappuccio is that the parties have been cooperating, working towards getting the jurisdictional discovery on the special appearance. We're going to keep our word on that. We will proceed and get what the parties have been working towards accomplishing on the special appearance, so that you can go forward with the special appearance. We're not taking the position, although literally the statute says you're supposed to shut it down. We're okay with you not shutting down the jurisdictional portion of the discovery, which is what we've all been working for. I've read every transcript. I know all the work that's been done. We're not setting any of that work aside. We're going forward with all of that to the extent that the parties are working on that.
To the extent that any discovery is being sought goes to the jurisdictional issue.
Yes.
I would think that we need to continue that. Otherwise,
technically, the statute says even that's supposed to shut down, but we're not taking that position. We're taking the contrary position. We're going forward with what the parties are working on.
very good.